Agricultural Exceptionalism, The Right to Farm Act by Laurel Stewart. Agricultural exceptionalism is the exclusion of certain standards and regulations set forth by the federal government, state, and local laws. These laws are designed so as not to disrupt the farming practices. Most laws date back to the 1940s. These exemptions tend to lean in favor of large corporate farms and not the workers, small farms, landowners, and the consumer. The exception for farms includes labor laws, Clean Water Acts, Clean Air Acts, tax laws, and the Right to Farm Act and other social and environmental regulations. Agricultural is at a center stage of rural environment and justice with little to no regulations. The Right to Farm Act differs from other exemptions because it was designed to protect farms from overdevelopment of urban areas. Initially designed to protect individual farmers, today they are increasingly used to protect industrial scale factory farms against the complaints of the neighbors. Each state has its own right to farm laws. Rhode Island has a unique law, and it was enacted in 1982. Massachusetts established the first Right to Farm Act in 1979. California enacted their law in 1981, again amended it in 93 and 99, and reviewed and updated it in June of 2001. New York State's Right to Farm Act states that the state's agricultural preservation law describes agricultural land as irreplaceable state asset. Rhode Island's Right to Farm law stands out from those in other states because it protects agricultural operations only from public or private nuisance lawsuits that specifically aim to enjoin or stop certain nuisance activities. Unlike those in many other states, Rhode Island's Right to Farm law consequently does not protect any agricultural operation from nuisance suits that aim to recover monetary damages related to the use and enjoyment of one's land or harm to the form of loss in property values. Right to farm laws were first developed in Massachusetts in 1979. This was due to the expansion and suburban growth of neighborhoods throughout the 1970s and 1980s. New residents began to complain to authorities about odors and noises, even though the farms were there first. So in response, the lawmakers proposed protections that safeguarded pre-existing farms. Article 97 of the Massachusetts Constitution ensures that the protection of the people in their right to conservation, development, and utilization of agricultural and other natural resources. Massachusetts General Law, Chapter 40A, Section 3, Paragraph 1, furthers this goal by stating that no local zoning bylaw may prohibit, unreasonably regulate, or require a special permit for the use of land for the primary purpose of agriculture. An example of when the Right to Farm Act did not benefit the farmer and decided in favor of the neighbor. In Petsy versus Cushman in 2002 in the state of Connecticut, the state Supreme Court upheld a $100,000 negligence award against Cushman Farms, a North Franklin dairy farm. The court ruled that the Cushman's farming operations unreasonably interfered with a neighbor's use and enjoyment of his property. The court used the case to clarify its position on the private nuisance law. Accordingly, the court found that a private nuisance can exist even where a defendant's conduct is reasonable, if the interference that results from that conduct is unreasonable. This interpretation may make it hard for farmers to defend against some private nuisance claims. The legislator could help farmers by requiring that any legal interference be substantial, or that the plaintiffs give the defendant farmers an opportunity to correct the interference before filing suit. The legislator could also limit the damages plaintiffs can receive. In this case, it was found that the farm had improper working equipment and was not fixing it. So in this case, had the farm been given the opportunity to correct the interference before filing suit, the farm would have then been protected by the Right to Farm Act.